Jessica, one of the questions that we got had to do with clarifying whether an employee who is asking for intermittent leave in the school context still needs to qualify for the leave, specifically in terms of whether the employee needs to be the only person available to take care of their child during that period of time.
So I think it's important to remember and keep in mind that anytime you have an employee seeking leave under the FFCRA, the very first thing you need to establish is the employee is eligible for and has experienced a qualifying event under the FFCRA. And so with regard to the child care school closure event, one of the elements for qualifying is that the employee who's seeking the leave is the only individual who is providing care for their child for the period of time they're seeking leave for. And so, you know, we've had it come up a number of times where an employee, you know, themselves is looking to be home, you know, and take care of their child during the school closure period, but the employee's spouse also is going to be home, or there's another individual or a babysitter or some other suitable individual also who is going to be there and available to provide childcare for the individual's child during the period of time the school is closed. And so that does raise a significant question in terms of whether the employee, him or herself, even qualifies at the outset for the FFCRA leave. Because remember, one of the things that they need to establish, or that we need to establish, is that they are the only individual who's providing care for the child for the period of leave that's sought. And so, you know, that is definitely an issue and has come up, you know, a number of times for our clients.
Thanks, Jessica. And another question we got quite a bit actually was, can you please explain the difference for purposes of FFCRA leave when an employee chooses to send their child to school on certain days versus when an employee can't send their child to school on certain days because the school is closed or having a hybrid model?
Sure. So again, this goes back to what I was just talking about with regard to establishing that the employee actually is eligible for and has experienced a qualifying event under the FFCRA. And so for this school closure reason, the qualifying event is that the employee is unable to work because the school is closed to that individual's child. In a hybrid type of context where the school is telling you or telling your child, you cannot come to school in person on days, you know, Monday, Tuesday, Wednesday, or whatever the case may be, the school is effectively closed to the child for in-person instruction on those particular days. However, we have seen situations where schools are giving families the option of either an in-person instructional model, or a remote instructional model, or a combination of the two, but that the school is giving parents and families the option of whether they want to send their child to school, or school in person, I should say, or attend instruction remotely. And so where it's not the school telling you you can't come in person, but it's the parent choosing not to send their child to school in person and electing remote, in that circumstance, the school is not actually closed to your child due to COVID-19. And so you have not experienced a qualifying event for purposes of the FFCRA leave. And so we've had a lot of situations come up like that. And it's very important to remember, the first thing that we need to establish is that the employee is eligible for and has experienced a qualifying event under the FFCRA. And so where it's their option, they're choosing remote instruction as opposed to sending their child to school in person, they've not actually experienced a qualifying event for those days.
Thank you, Jessica.